Welcome to fourth lecture on technology transfer through strategic alliance. Now, I will mainly concentrate on regulatory issues. If you heard my previous lecture, I have referred these particular regulatory issues in several times, and I said that regulatory issues may pose a difficulty for a strategic alliance, and one need to be very careful about these particular regulatory issues. So, I read a quote from Mary again, and she said that as varied as the purpose of the strategic alliance are, so too are the legal structure that embody them. In fact, these structures are often fall along a spectrum ranging from the traditional contractual arrangement to the joint venture to the corporate acquisition. So, she is talking here about the forms which the strategic alliance might take after the parties to the strategic alliance enters into an agreement. See, in generally, if you look into the form of a strategic alliance, which I have also told in my previous lecture, it might be a simple contract or a hard contract, or it might be a very loose associations between the parties, which may come through the process of memorandum of association and article of the association. So, what I place it here as a traditional contract, or call it here as a traditional contract. In the traditional contract, generally it do not create a new business organization or new business form, or rather it do not take any business form. So, what the parties of the strategic alliance do, they divide the work between themselves and they mutually carry out this particular work in either in terms of production, or in terms of accessing the market, or in terms of further development into a particular market, or even for the product. Like many of the time you will find the strategic the partner in the strategic alliance do import the goods into a particular market, or I should say unfinished good into a particular market, then they assemble that particular product and then they sell into a market. Like if you are importing a particular product into a market, then possibly there might be higher regulatory taxes, or there might be higher regulatory compliance cost. So, if you are just bringing that raw material and you assembling into the domestic market, then in that case the cost will be lesser. So, in this case what basically happening, your partner is only assembling that particular goods which you have manufactured in, or component of the goods which you have manufactured in some other places, and they are bringing that particular raw material or the manufactured components, and they are bringing into a particular country or in India, and they are creating the finished product. Now, there is a several example of this type of process. You will find when this luxury car brand came into the India, they started they started assembling their product in India, and they used to take the help of the local manufacturing in doing so. So, similarly you will find in case of IT and ITC product, like few companies in India nowadays manufacturing these or assembling these phones, mobile phones or cellular phones. Similarly, few companies who are assembling these televisions, and they are branding in India. Even some company you will find they basically bring the drugs molecule from other country, and then they assemble it or they package it in India and then they sell in Indian market. So, there is a several kind of arrangement you will find. So, whenever we are talking about the traditional contract, we are basically talking about this particular system where basically people do divide the responsibility amongst themselves and the partners do to help mutually to each other, and they really do not do jointly manufacturing jointly. Now, the second category is called equity investment. Now, in case of the equity investment, it might so happen that partners it not only transferring the technology to you, but they are also making an investment into the equity of your company. Now, when we are talking about the equity, it means they are making an investment in the company's capital, either in form of capital instrument or in form of a debt instrument. It depends on what kind of an instrument your partner is bringing in your organization or in your company, depending on the regulatory regime, because most of the time the market regulator specify that what kind of investment you can bring into your partner organizations. Now, the equity is a generic term. So, even if it is a capital investment or the investment in a capital nature or investment in the debt, it both the cases if people call it equity. Now, when people are making an equity investment, they also try to have some control within your organization, or they want to have some kind of a managerial control within the organizations. Now, I am going to elaborate this particular process maybe little later when I will talk with you in joint venture, but nevertheless, let me tell you, sometimes even do people try to have their negative control over the management. Negative control in the sense, like if you are bringing a debt instrument or making the investment through the debt instrument, you do not have a control over the management. But what people do while they are developing the investment agreement, they do put the clause wherein they say that, well, if there is any major decision the company wanted to take relating to this issue, then in that case they need to consult back to their partners. So, the equity investment is quite common, and nowadays you will find more and more equity investments are coming in the process of the strategic alliance, because the company who is transferring the technology into a market, they also wanted to have some kind of a control about the product which will coming out of that particular technology transfer, and when those particular product is been marketed into the different jurisdiction. So, equity investment is getting pretty common. Now, joint ventures are almost order of a day, and you will find wherever there is a very high and sophisticated or capital intensive technology transfer, people are going more and more joint venture. Like yesterday in my lecture, I have referred about the defense production, and then I said that people are now making an investment in India to produce a defense equipment, defense defense vehicle, or maybe some kind of a tanks, or maybe the fighter jet, or maybe so much so forth. In those particular case, it is not only the technology intensive, but it is also capital intensive. So, the company who is bringing the technology, or the whenever the local partner is choosing the their outside partner or foreign partner who is bringing this particular technology, they are also interested that they should make an investment through the joint venture too. And this is also quite important for the foreign partner to come through this particular joint venture, because through this particular joint venture they might have a better control over the product which they are going to manufacture through this particular technology transfer. And even sometimes the regulatory requirement insist for the joint venture into that particular product itself, because because they insist that if there is a joint venture, I mean strategic alliance outcome is a joint venture, then in those particular circumstances the company may purchase some of the assured quantity from this particular joint venture. So, what they insist on that you create a joint venture, because the moment you are creating a joint venture, you are basically putting up a new organization, you are creating some kind of a market, you are also absorbing the local labors, you are also using the local capital, you are also using the local infrastructure, you are also using the local resources or the raw material for producing your particular product. So, it actually helps even the government to government to get economic development of that particular region. So, government many of the time insists that the company should come through the joint venture. Now, the next one is the merger and acquisitions, and you will find this is also getting quite common in Indian market, and I believe once we have opened our market, this merger and acquisition is become an order of the day. Now, it is not only the inbound merger, but there is also outbound merger and acquisition is happening. Inbound merger in the sense that means the foreign companies are merging with the Indian companies, and they are also aggressively acquiring the stake in Indian companies. At the same time, you will also find that Indian companies going out and acquiring the different company into the different market, and at the same time they are merging with the different market. Importantly, you will find there is a dedicated section now in the Companies Act 2013, which talks about the foreign merger. Previously, there was no as such dedicated provisions, but it used to be handled under the usual amalgamation and usual process of the arrangement. But now you will find that there is a specialized provision has been created for this particular purpose. Now, merger and the acquisitions give a lot of flexibility to the companies to go for expansion, to go for acquiring the new market, to go for getting the new businesses. Some people even wanted to go for merger or acquisition because they want to have a new learning into their organization, because they are also having the business in the same segment. They wanted to acquire that particular company because the company they are targeting, they have a lot of knowledge base of the product which they do produce in other market. So, they can transfer some of the technology out of this particular process. Like if you look into the automobile sector in India, then you will find these particular practices quite common. Like Tata went to acquire this Jaguar and Land Rover. Then you will find Mahindra went and acquired some of the Korean company who are the best in SUV. So, there is a lot of example you will find, not only in case of automobile sector, even you can find the similar example in pharmaceutical. You will also find similar example in case of other service providing, so much so forth. So, there is a several example you will find into this particular thing. Now, the important thing over these particular issues is the matter relating to the governance, then control, fiduciary duty, and all these particular issues. Let me try to explain these issues, that what should be the governance structure in your strategic alliance. Because as I have told you that strategic alliance formation depend on type of the market where you wanted to do the business, or at the same time the type of the business which you wanted to pursue. So, the governance structure also depend on those particular particular market where you wanted to do the business. So, one should be careful that what should be the adequate governance structure or the control which we wanted to exercise over the over the organization or the relationship which you wanted to bring through this particular strategic alliance. Similarly, uh, there might be some kind of a major legal considerations which you need to do, because the local government or the local institutions wanted to get the protections again protection in their business. Many of the time you will find there is a kind of restrictions for the foreign partner to enter into the local market, even with the local partners too. They might not be even allowed to have a higher stake into the market. They wanted to have a minimal stake into the market, but at the same time, whenever the foreign entity wanted to enter into the market, they want to have some kind of say into the management of this particular company. So they try to ensure this particular thing through the different means. Now, another issues which you should keep in the mind is relating to the matter of competition, which I have referred before as a fair regulators, fair market regulators, because now competition law is in place in India, and before you go for any strategic alliance or you go for equity investment, joint ventures, or even merger and acquisition, you might need to go back to Competition Commission of India to get their permission before you start this particular process, because uh, your strategic alliance should not create a concentration in the market, or should not create a adverse impact over this particular market. And if it create adverse impact over the market, then in that case you will not be allowed to enter into this particular strategic alliance, or any of the form which might come out of this particular strategic alliance. So you need to go back to CCI, which is popularly known as Competition Commission of India, and you need to take the permission under the concept called combination. Combination should not create a market polarization, should not create a market polarization, and if it is create a market polarization, then you need to go back and ask their permission into this particular process. Now, the fiduciary duties is becoming more and more important in case of India. Like we are started talking in India about the arm's length dealings, and we are talking about the parties who are connected and dealing with each other. So those particular process now very strongly scrutinized by the market regulators. Maybe it might be you might come under the scanner of SEBI because of this particular thing, or it might be a very close dealings which might create a create sort of a scrutiny for different regulatory agency, including the taxes. So let me take you the other issues which you might find in case of your strategic alliance. It might be relating to the Pacific tax issues, which may come because of the type of alliance you have chosen, because I have told you that strategic alliance may be take several forms. So the tax implication will depend on which kind of a form you have chosen for the purpose of your business. Then it might be relating to the intellectual property ownership right. If it is simply the contractual relationship, or traditional contractual relationship, or hard contractual relationship, or informal contractual relationship, the ownership of intellectual property which might develop during the process of this particular strategic alliance may differs, because intellectual property law spell out very clearly who is going to have a ownership over the intellectual property which is developed during a particular type of alliances. Now, if it is a joint venture, then the ownership of intellectual property will be different than if it is a merger, or even if it is a simply a partnership which people has entered upon at the time of strategic alliance. So you should be very careful about this particular thing, and if you find that there is a no as such legal regulatory frame is available for you, then in that case you should develop that particular regulatory that particular frame through your contractual process, so that when you decided to part from each other, it is not create a bottleneck for you. I have already talked about this competition issue, which is also known as antitrust issues, and you need to be careful that by your essay is not going to hit the provisions of the Competition Act, and you should be careful that it is not going to be a combination into the market, or your alliance should not create a kind of a dominance into the market, or dominance per se is not a bad, but if somebody said that because of your dominance you are abusing the market, then in that case it is going to go against you, or you should not it should not create a kind of appreciable adverse effect into the market. So, one need to be careful about this particular scenario. Now, the next issues is regulatory environmental regulations, and you will find the environmental regulations became more and more complex over the years, because in case of India, main focus is on anti-pollution for pollution, then that of environmental governance, and because of that particular thing you will find there is a multiple legislation in form of federal legislation, in form of a bylaws, in form of a regulation has been developed, and you need to comply all those particular regulation. And some people said that even to get environmental clearance you require a more time than to process the business into a market, like sometimes even it might take 2 years, 3 years, depend on the particular government policies. Sometimes you will find government is very strict into the environment compliance matter, and at the same time relating to the environment compliance matter also, court is quite vigilant. People court gives a very strong stricture if people can prove that while these particular alliance might going to create some kind of environmental impact through their production into a particular region, and that particular region is somehow ecologically vulnerable. So you should be careful about this environmental regime, and there is a several laws is there. Rather, I should say it is become more and more complex, this particular environment compliance, and many of the time it is very difficult to get through these particular environmental regulators in the different stage of your business. Now, apart from that, there will be other sectoral regulatory issues. It is depending on which sectors you are doing the business. Like if you are some sector like power generation, if you are in the sector like the financial product, if you are in the sector like some kind of a manufacturer like defense equipment or some other equipment, or even if you are pharmaceutical manufacturing and all this thing, apart from all other business regulation, you need to look into what are the regulatory frames for that particular sector itself. And these sectoral regulators mandates varies from each other. Some of them are very complex, and very complex to comply also, and it is also very costly to do the compliance into this particular sectoral regulation. So, you should map it properly. You should know that what are the regulation you need to comply with. Many of the time you will find if you are missed out, or if you are failed some of this particular compliance, it might trouble in your business, or when you have started the business process you might be stopped because you have not complied this particular process. The last one is relating to the cross boundary issues. Now, cross boundary issues may arise because of the several reasons. It might be relating to the foreign investment law. It might be relating to some kind of protection relating to the dumping. There might be provision relating to the anti-dumping. There might be some kind of provision of national treatment, so much so forth, which basically going to be governed by the bilateral treaties, which might be governed by some of the international understanding, which might be governed by some of these local laws relating to this particular effect. Please remember, India is not a monist country. That means whatever the international law India is signed, or international treaties India is signed, it is not automatically implemented in case of India, but it has to go through this domestic framing of the laws. So, it is a quite complex in case of the cross boundary transaction, and you should be aware about these nuances which might going to affect your strategic alliance. So, thank you very much.